Hello students, in this video we are going to do the latter part of your chapter, that is High Court and the Subordinate Courts. Yesterday we have done about High Courts, its powers and functions. We did it not in detail because obviously most of the things are very similar to Supreme Court. So here let's take up the second part of the chapter, that is Subordinate Courts, which is slightly different from what we have done in the previous topics about Supreme Court, High Court, all of them. So it's slightly different from them. So let's quickly get down to the reading and then explanation of the topic. So here we start with subordinate courts. Now, first and most important thing is structure and composition. So subordinate courts are the courts which function at the district level. So as we know, Supreme Court is basically the one and the only court for the entire nation, whereas high courts are supposed to be one per state. At times there might be a particular one high court looking after more than two or more states or union territory and a state, and so on. But when we talk about subordinate courts, first of all, the highest category is the district courts, and they are supposed to be, each district should have at least one district court, and that is why subordinate courts are at the district level and even below. Therefore, all the courts in India except the Supreme Court and High Court are all subordinate courts. So all the other courts and in a particular state, whether district level or even at a lower level, they are all called as the subordinate courts. The organization and structure of the subordinate courts are generally uniform throughout the country. That means in every part of the country, in every state, everywhere, subordinate courts are going to have the same kind of structure. It is not going to be very different from each other, that you might say that it is a totally different category. It is all the more going to be the same particular concept of how subordinate courts should have the proper composition and how they should be working. For the purpose of judicial administration, every state is divided into various districts, and each district under the jurisdiction of a district judge. So all the courts are in every particular district are supposed to be headed by a district judge, and every district has different types of courts, and they are civil courts, criminal courts, as well as the courts of revenue. So let's take up first the civil courts. Under the civil courts, first is the court of district judge, and similarly we have the sessions judge also, but that is in the criminal cases. But let's get down with the explanation, then we'll clarify it. The court of district judge, it is the principal or the highest court of district, and it can decide both the civil as well as criminal cases. So when we talk about civil courts and criminal courts, it does not mean that we have two different courts. It is one and the same district court, but when it is hearing a civil case, it is called as a civil court. When it is hearing a criminal case, it is going to be called as a criminal court. So here, this district judge can hear both, district courts can hear both the civil as well as criminal cases. When a judge decides civil cases, he is known as a district judge, and when he decides over a criminal case, at that time he is called as a sessions judge. So it is neither the court is different, neither the judge is different, only the titles are different when they are hearing different types of cases. For civil case, it is a district judge and giving a decision in a civil court. For a criminal case, it is a sessions judge giving a decision in a criminal court. So that's the only thing, just for the namesake. So in some districts, additional judges are appointed by the governor in consultation with the Chief Justice of the High Court, not of the Supreme Court, Chief Justice of the High Court of that particular state itself. In order to be a district judge or an additional judge, a person should be an advocate 7 years altogether in the judicial service. And usually the district judge also acts as a deputy commissioner or the district collector. In that capacity, he maintains law and order as well as supervises the collection of revenues and taxes from that particular district wherever he is appointed as a district judge. So he is even a district collector also and a district deputy commissioner over there. Besides that, the next category is slightly lower than the district judges, the court of civil judge. The next category is designated as civil judge. This post is sometimes combined with the post of a chief judicial magistrate and can try cases punishable and with imprisonment only up to 7 years. So we can see the distinguishing feature is the punishment they are capable of giving, and here where district judge can give any particular condition punishment, not the death sentence and life imprisonment, but little lesser than that. But on the other hand, civil judge has even less capacity of judgment, and that is just imprisonment of 7 years, and is also called as chief judicial magistrate's office, also court also. Next is third category, which is slightly even lower, is the munsif's court, and they are supposed to hear civil cases involving not more than 20,000 rupees. Appeals against their decision lie in the civil judge, with the civil judge, and there who's the next higher authority to them, the civil judge. That is, we have just done the court of civil judge. वहाँ पर इनकी cases appeals will go as per the appellate jurisdiction we are talking about. There are several civil courts working under the district judge, such as the court of subordinate civil judge, the court of sub judge, and the court of small cases. So among all these smaller courts, this is one of them, munsif's courts, which is known as the court of sub judge. If you look into your books, you will get the name. The court of sub judge is called as the munsif's court. The third that we did was the court of small cases. Now let's talk about that. Here we see these petty courts are headed by the junior most magistrates and have jurisdiction in cases where the value of the subject matter is very, very small. The very petty cases, the simplest cases, they are heard over here in these small cases, that court of small causes. And the value of the suits are fixed by the state government from time to time. It is not that they can hear the fines or cases of that particular limit of money or fine or anything. That is always, you can see it keeps on differing, changing as per the rules of the government. Besides that, the term of office, the district judge and additional district judge, they are appointed by the governor, and that is done in the consultation with the high court judges, as well as of all the other important judges, the senior most people of the court. District judge, we can say, except the district judge and the additional district judge, all other judges are appointed through competitive papers. It is not the appointment by the president or any such authority. It is through the competitive papers, that is State Public Service Commission. So Public Service Commission examinations are cleared, and then a person can get into that. The rules regarding the transfer, leave, and condition of service of the district judge, additional district, are all given as per the, are all taken as by the rules and regulations by High Court. So High Court is basically the supervising authority over all these district judges, district courts, all subordinate courts, and then High Court will give the same report to the Supreme Court, all the High Courts. So that is how this all is basically a unitary way of all the district and subordinate courts reporting to High Court, and all the High Courts reporting to the Supreme Court. And obviously Supreme Court's Chief Justice can even report to President if the President wants to know any report, but we know that judiciary is kept separate. So usually, unless and until it is too important, this President will never ask, or Parliament will never ask for any kind of such information. Then we see the criminal courts. Let's come down to the criminal courts. Classification is, first is any civil, like just the civil courts, civil cases. Criminal courts, the highest authority at the district level is called as Sessions Court. It is the highest authority, and usually it is presided by the district judge only, but in terms of criminal courts, criminal cases, it is called as the Sessions Judge. And it can the Sessions Court deals with cases concerning more serious offences such as robbery, dacoity, and even murder also. It is the session or the additional sessions judge alone can give death penalty or life imprisonment also. So even at the district level they can give that, although it has to be rectified and agreed by the High Court itself. So then it can be awarded. Usually people do not take the life imprisonment and death penalty even in the district level only. They take the court as an appellate case to the High Court, and there it is rectified and ordered. So accordingly you can say. Why? Because a death penalty is basically, it comes under the fundamental rights of life for a particular, maybe the accused or convict, whatever you may say. So for that person it is fundamental rights, and it can be taken to the Supreme Court also. But usually if it is a very grave and serious matter, it can be just then and there given the decision by the district court, the same decision by the High Court, and so there is no point taking it to any higher authority. Then next is Court of Chief Metropolitan Magistrate or the Chief Judicial Magistrate. Just like in the civil cases, you have the Court of Civil Judge or Chief Judicial Magistrate. Here also we have the Chief Judicial Magistrate, who is also called as Court of Chief Metropolitan Magistrate because it is in the sessions or it is in the criminal cases. They cannot give a death sentence or a life imprisonment, but they can only pass an imprisonment up to 7 years, just that what we have done in the civil cases. Next is next category. The third category is Court of the First Class Magistrates. They can give a punishment only of 3 years, up to 3 years, or otherwise a fine of 5,000 rupees or even both of them. Next category is Court of Second Class Magistrates. They can give a punishment of not more than 2 years and a fine or a fine of 1,000 rupees or at times both of them. So these are the various you can say classifications of the courts in the terms of criminal cases. Then appeals. As the Indian judicial system is a single integrated system of court, appeals can be made in the higher courts against the orders of the lower courts. So all these district courts and all the courts even below that, all those wherever the decision is given, if people are not satisfied with that and they have enough money to take the case to a higher level, they are free to do that because it is all one under the other. So when you are going, you can go as per the proper procedure from a lower court to a higher and then to an even higher and ultimately going to the high court and then Supreme Court as per the demand of the case, if you have all that particular time and money and you think there are possibilities of a change in the decision. Next we see the courts of revenue. Now the courts of revenue have various particular categories. Like first is the Board of Revenue. It is the highest authority in the field of revenue in state. It works directly under the High Court. So the Board of Revenue is basically directly headed by the High Court. Then next is Commissioner's Court. A commissioner generally has 3 to 4 deputy commissioners under him, and he looks after the assessment and collection of all the revenues in the district. So collection of revenues is directly headed by commissioner, and his particular office place is known as the Commissioner's Court, where revenue is collected. Collector's Court. The court is generally headed by the deputy commissioner. We know the commissioner has deputy commissioners under him. So all the deputy commissioners' office, they are known as the collector's court. And the deputy commissioner is basically he's helping the revenue department in the process of assessment and collection of the revenue. So they will be collecting it and they will be passing it the information to the commissioner in the commissioner's court, and that will pass on the report to the high court. So it is a chain of courts which have the procedure and the information passing from one to another. Next is Tehsildar's Court. A Tehsildar is responsible for collection of revenue and property taxes. So that is related to not land revenue but the property revenue as assessed by the Naib Tehsildar. And Naib Tehsildar is slightly lower than that, who has given him just the information. So here next is Naib Tehsildar's Court, and this is the lowest court. He hears cases relating to the assessment and land revenue, property taxes from farmers, and appeals against their assessment can be taken to the Tehsildar's Court, and so on and so forth. It does not mean only the collection of the revenues taken by these courts, even the cases related to all the revenue, land revenue, property taxes, all these tax related cases, they are taken into the revenue courts, and these are the various revenue courts. It can be taken to Tehsildar's Court, and then it can be taken to the Collector's Court or Commissioner's Court, and so on to the Board of Revenue as the highest authority of revenue courts, and ultimately going to the High Court. Then they come to the proper line of courts to the High Court. Otherwise it is a totally separate line of courts when we talk about revenue. Next we see Lok Adalats. Lok Adalat are called as the People's Court on the recommendation of Justice P. N. Bhagwati. You should remember the name. Lok Adalats was set up by the Legal Service Authority Act of 1987. And it was a legal forum to provide legal aid and quick justice to those who are not in a position to engage a lawyer, because obviously you have to give a fee to the lawyer, you have to give a fee for the registration of the case in the courts. So those who are not able enough to pay all those procedures, all those fees, they are supposed to get easy and quick justice through the Lok Adalats. And that was the Legal Service Authority Act 1987 provided the states or district authorities shall organize lok adalats from time to time, so that general people can come and have, and designated people are sent over there to give the decisions, to hear their problems and try solving their disputes through mutual consent, through mutual you can say adjustments and a little bit of taxations, fines or whatever, but without taking in the case any further. Then and there the decision is tried to be given. So we can say the Lok Adalat serves the following purposes. First, to provide legal aid and quick justice without any of the for the people, those who are not in a position to engage a lawyer. And then second is to relieve the court of heavy backlog of cases, because these small cases which can be heard then and there and given a case, for no reason they keep on piling on the files, and for dates and dates together they are kept over there waiting. And obviously the higher courts have a lot of other cases of more importance to be dealt with. So in that case, to remove that burden, these Lok Adalats play a pivotal role to ease the burden. Next is to eliminate high costs and delays in imparting justice. A lot of money is spent in filing a case, in getting the suits and the dates heard, and properly fees is taken by the advocates, by the lawyers for the judgments and everything. So to avoid all that costly display of judgment, it's better that we have the Lok Adalats. We talk about advantages of Lok Adalat. We have already done it. Lok Adalat play important role in settling disputes of family feuds, disputes between neighbors, minor cases. Besides that, important thing is Lok Adalats deliver faster as well as inexpensive justice even to the people, those who are not in a position to afford all that expenses. Lok Adalat reduces the workload of the higher courts by dealing with most of the cases which are smaller and can be solved then and there without the higher courts getting involved in it. And then Lok Adalats promote social justice by providing legal aid to the weaker section of the society. So these are the various advantages of the Lok Adalats. Scope of Lok Adalat, we see the system of Lok Adalat has now become so popular that the various government departments like the telephone department and electricity board has begun to hold Lok Adalats, solving hundreds of cases in a single day obviously for their particular departments. So they can have these Lok Adalats, and cases related to that particular thing can be solved then and there. It is the need of the hour that Lok Adalats are organized more frequently and their jurisdiction is expanded, so that they can take up more cases. They can have the capability of giving higher amount of punishments also. So that is all to be taken up by the people, and that government, if they give the authority to these people in the Lok Adalat, then obviously it is going to be beneficial for the government itself, for the you can say judiciary part itself, if Lok Adalats are given more powers. Next we talk about the family courts. People might talk, what is the difference between Lok Adalat and family court? Obviously Lok Adalat is also listening to the family disputes, but here let's talk about family courts. So when we are talking about family court, it came into being from Family Courts Act 1984. That is even before Lok Adalats were formed. They were in 1987. This is 1984. It was enacted to secure speedy settlement of disputes relating to marriage and family affairs. Totally into the marriage and family affairs they deal with. The act provides that family courts would be set up in cities having a population of more than 10 lakh people. That means in big cities they are supposed to have family courts where there are huge number of people, obviously a lot of families, and they might be having a lot of disputes. So instead of taking all those cases to the courts or to the Lok Adalats everywhere to ease out the burden, such places, the bigger cities, do have the family courts where all these cases can be heard without even taking them to the Lok Adalat. So it is like an assistance to the Lok Adalat, although it is an earlier particular formation. Lok Adalats are basically the later part. So Lok Adalats can take little burden of the family courts where the cases are very serious, grave, and they can be taken to the Lok Adalat and even to the higher courts then and there according to the situation. So with this, we come to the end of the subordinate courts and the high courts. We have done all of them. For better understanding, you can go through this chapter once again, and we will be doing the question answers of this chapter in the next module. So with this, we will come to the end of the entire civics syllabus, and then we will move on to your history portion, which is left for the board examinations. So do well your civics part. we'll do the question answers. Keep your work up to date. All the best. And then in the next module, we will straight away start with the question answers, and after that with the civics portion. So with this, we come to the end of the module.